Hello and welcome to Taylor Wessing's webinar on how to prepare for Brexit. My name's Paul Callaghan and I head up the Employment, Pensions and Mobility team here at Taylor Wessing. Brexit provides all businesses with tremendous opportunities but also certain challenges in order to be ready for the change that's going to happen to the UK's status. On the 29th of March, Theresa May, as the British Prime Minister, triggered Article 50, which formally gave notice of the UK's intention to leave the European Union. What that means is that in all likelihood the UK will leave the EU in 2 years' time, so on the 29th of March 2017. It is possible for both sides to agree an extension to that timetable. It's possible that the UK could leave earlier, and some commentators think that it's possible to revoke our giving notice to leave. But for now, it's reasonable and it's sensible for all businesses to prepare and operate on the basis that in 2 years' time, the UK will no longer be a member of the European Union. In the meantime, however, for the next 2 years, everything remains as it is. So all EU laws continue to apply to the UK, and the principles of freedom of movement and access to the single market also continue, at least until the 29th of March 2017. Upon triggering Article 50, the government brought into the House of Commons what has been known as the Great Repeal Bill. In fact, what that does is repeal the European Communities Act of 1972, which is what created the UK's membership of the European Union. But in reality, for now anyway, the so-called Great Repeal Act is actually bringing all of the current EU law into UK law. So rather than repealing EU law, it's actually incorporating all EU law that can practically be incorporated into UK domestic law. And certainly, even when we've left in 2 years' time, there's not going to be any immediate change. The UK will continue to be subject to all EU laws, at least that are in place on that date. Going forward, if there is a conflict with EU law in terms of what the UK Parliament decides to introduce, then UK law will take precedence. But it's going to be a fairly long process before we see significant divergence between UK domestic law and EU law. And the government was very keen to make clear in its white paper introducing the Great Repeal Bill that it intends to ensure that workers' rights, environmental laws and consumer laws in particular are protected, and so that those laws that have been introduced in those areas by the EU are likely to continue in place. What it does mean is that the UK will be free to reduce business taxes, which is potentially going to make the UK even more attractive as a place to do business, and ultimately create less regulation generally than we've been able to as an EU member. So that means that there are an awful lot of opportunities for businesses to do more in the UK, to invest in the UK, but preparation is key. There are a number of areas where businesses do need to be ready for potential changes. And we've got a good team here from Taylor Wessing that is devoted to helping clients with their Brexit strategy, covering all of the main relevant areas of law. And to start with, one of the most important areas to be dealing with and to be thinking about now is immigration. And Vikki Wiberg, who's a senior counsellor in our team, is going to discuss what you should be thinking about and doing now.
Thank you, Paul. As Paul said, immigration is a key factor really for businesses to be looking at at the moment. It's clear that it was a key factor behind the referendum decision, and there is widespread concern in the UK about perceived uncontrolled EU migration. There are about 3 million EU nationals living in the UK at the moment, which is about a third of the current non-UK nationals living in the UK. So there's a big group of people living here. It's important to note that, as Paul mentioned, there is still freedom of movement of EU workers, and that will continue until we Brexit Europe. The referendum, however, has seen some uncertainty already. We've seen the number of EU entrants to the UK dropping since September 2015 from about 60,000 to 30,000 a quarter. So while there's no change to the rights of EU nationals to live and work in the UK, clearly the uncertainty is having an impact. The white paper that Paul mentioned has made it clear that EU national migration is going to be a priority for agreement, and that it's something that's going to need to be discussed as part of the negotiations moving forward. But for now, it's business as usual. EU workers have the right to live and work in the UK. UK employers can continue to recruit new EU hires from overseas, and UK citizens can continue to work freely in other EU countries, and in each case no visas are required and no prior immigration permission is needed. The negotiations over the next couple of years are going to have to deal with the rights of EU citizens and their family members, both from the EU and non-EU family members, to remain in the UK, as well as probably mirroring rights for UK citizens and their family members to remain living and working in Europe. We're going to need to have certainty about the cut-off date for permissions, so at what point the right to work will change, and cut-off date might be, for example, the 29th of March. It might be a future date. We're going to need to see what that will be. We're also going to need certainty about the process to register someone's status in the UK and in Europe, and these are all going to be matters that we're going to need to think about in detail. But there are things that you can be doing already for your UK-based workforce, and it's important to think about these things now and to put in place policies for the next couple of years. We'd really recommend at this stage looking at your UK workforce, auditing the numbers of EU national employees that you have in the UK and how long they've spent in the UK. Are these people in business critical roles, for example? Do you have lots of EU nationals in particular areas of your business that you might need to think about how you're going to manage their status in the future? You might want to provide some reassurance for your staff already as to their ability to remain in the UK. EU nationals who spent 5 or more qualifying years in the UK are able to apply for a status called permanent residence. And that means that if they've been working, studying, self-sufficient or seeking work in the UK for the last 5 years, they can take themselves outside of any future immigration rule changes by holding permanent residence. It can be a step towards applying for British citizenship, but it doesn't have to be. So for people who can't hold dual citizenship, this could be a destination in its own right. But you might have employees who have children who've been born in the UK. They may already be British nationals and could apply for British passports, and it would be useful to talk to those staff members and see if you can assist them. You may have staff members who've been in the UK for less than 5 years who aren't eligible for permanent residence, but they can apply for a document called a registration certificate, which would certify their status in the UK and be something they could produce in the future if they were asked when they first moved here. There are expedited services that the Home Office rolled out from October 2016, and there's an online form and a passport checking service, which means that your staff do not need to send their original passports in with their applications. And that's really useful because I'm sure that many of you have staff who travel a lot and would be nervous about giving up their passports for prolonged periods of time. So those services are really useful. I'd also recommend that you consider, as part of looking at your current workforce in the UK, your future resourcing. What we do know is that if the Home Office introduces a requirement for EU nationals to obtain visas in the UK, much like for non-EU nationals, that's going to lead to longer lead-in times for transferring staff to the UK. It's also going to lead to more compliance and cost requirements for those staff members. So looking at your staff and your resourcing now, before any changes come in, might be cost-effective for you. You should also really look at your British citizens. You might have British citizens in the UK who actually travel a lot. You might have citizens that might be eligible for dual citizenship, for example, through EU ancestry or from living in other parts of Europe for a long period of time, and it might be that they wish to apply for EU citizenship to enable them to continue to do so in the future. And again, if you are looking to move staff members overseas to other parts of Europe, you might want to think about doing that now rather than after European rules might change after Brexit. So that's a bit of a snapshot about some practical things you could be doing now to help your EU national staff living in the UK prior to the future changes. I'd now like to hand over to my colleague Sian Skelton, who's going to look at commercial and contract changes.
Thank you, Vikki. So I thought this afternoon we'd just talk a bit about commercial contracts. And although there's been uncertainty in the market since Brexit, since the vote for Brexit, there's been no immediate change in the commercial contract regime in the UK or across Europe, and we're not anticipating that there will be any specific change. With respect to consumer sales, the UK government has stated that they respect the need for there to be a stable legislative framework which mirrors the EU, which will enable consumer-led businesses to continue to sell to the very valuable market that is Europe. The government have come out and said specifically that they will continue to reflect EU consumer legislation and in particular consumer protection regulation, which will hopefully give comfort to UK consumer-led businesses, but also to European consumers who will and businesses that receive UK consumer goods. What businesses operating across Europe should start doing is to consider the impact of Brexit on their long-term commercial relationships. In light of Brexit, longer-term and high-value contracts, or those which may be subject to currency exchanges or territorial restrictions, should be considered more carefully prior to being entered into. Again, those with consumer businesses will need to ensure that they continue to comply with the relevant consumer legislation. Broader thinking about what Brexit will mean for your business may affect, and how it may affect your commercial position it's invaluable to start doing that now. When you're reviewing your longer-term contracts or your high-value contracts, it's worth considering some of the following terms to consider whether you need additional rights which may come into play once exit occurs. So, for instance, things like the termination rights. Does the business need the right to terminate on Brexit? This might be especially the case where the contract is no longer commercially viable post an exit. Currency and fluctuations. How will these be affected in the contract? Is it likely that we'll see quite volatile currency fluctuations? And again, do you need to bake those into the contract now, or do you need the right to terminate, or to have another mechanism to review how currency is dealt with within the contract? Trading tariffs and price increases. We don't know what the trading position the UK will be able to negotiate as part of Brexit, and what those customs duties will actually be for doing business with the EU. It's possible that those customs duties will be higher than what the businesses are dealing with at the moment. And again, this goes to the price and commerciality of the contract. Again, it's worth thinking through these things, and again thinking about whether to bake in the pricing, whether to have the right to terminate, to renegotiate, should the position be less favourable than you anticipate at the time you enter into the contract. Territorial restrictions. This is particularly important where you have exclusivity, especially in territory provisions. If they're dealing with EU territorial provisions, does the EU include the UK after Brexit or not? How specific do you want to be? Where does the line sit? Is it in your favour to be part, for it to remain within that contract, or to fall outside? Again, worth thinking about when you've got these specific provisions. And finally, intellectual property. Again, is it worth considering whether it's appropriate to solely rely on the EU level protections? So the position you start to take in your commercial contracts will be business specific, but it is worth starting to think about the implications of Brexit more broadly, and to consider what, if anything, you need to start changing in your contracts. I'm now going to hand over to Tim Strong, who's going to talk about the disputes angle.
Good afternoon, everyone. As a litigator, I'm acutely aware that no one really likes talking about disputes. But this is an area where Brexit potentially has a huge impact, and it's important to be aware of how and of some easy steps you can take to improve your position. It's principally about challenges, though, not really about opportunities. This is an area where EU law dominates. We have the Rome I Convention for contractual governing law, Rome II for non-contractual governing law, the recast Brussels regulation for jurisdiction and recognition and enforcement of judgments, and finally, we have the service regulation. And all this has direct effect, and the key parts are dependent on reciprocity. So the Great Repeal Act is not going to assist us here. We'll need specific new arrangements, or we'll have to fall back on old legislation or even the common law. Now, this is an area of particular concern to the government, Parliament and to bar associations. It's been identified as a key area of uncertainty for business in every report of substance that's come out of the UK government and Parliament. And it's a concern that's shared across Europe. These provisions operate both ways, and so much international commerce touches and is financed out of the UK, is subject to English law and with English jurisdiction specified. But lack of reciprocity is more of a problem for the UK, but has a real impact across elsewhere in the EU too. Now, there are some potential ready-made solutions for jurisdiction and enforcement of judgments, although they're not as good as the recast Brussels regulation. The Lugano Convention applies for Norway, Iceland and Switzerland. There's the old Brussels regulation. And there are some interesting proposals, for a lawyer at least, for the ECJ to become a procedural court of last resort for jurisdiction disputes. But all of these require the EU's agreement, and they still involve the ECJ, which is often portrayed as a line in the sand in Brexit discussions. Less contentiously, the UK could ratify the Hague Choice of Court Agreement Convention, but that would only ensure recognition of exclusive jurisdiction clauses and wouldn't help with enforcement. So the current position is you need to consider the impact of a so-called hard Brexit as your default assumption when you're assessing the risk of your dealings with third parties. And the simple point is that all these conventions will in that event fall away. At the moment, EU law enforces party choice of governing law, both contractual and non-contractual. In the case of contractual governing law, we have a 1990 Act that would apply, and it's fortunately one area where there would be no real change. It should result in a contractual choice being upheld, or if you don't have a contractual choice, the governing law will be determined by the most closely connected test, and that is pretty much what happens under Rome I. For tort, the position is a little more difficult. There's a 1995 Act that would apply, but there are two important differences to Rome II. The first is that it doesn't recognise contractually specified governing law, and the second is that the governing law becomes the law where the tort occurred or where the significant event related to it occurs, not where the damage occurs, which is what happens under Rome II. Now, this is particularly important for those of you who may be selling professional services who potentially face liability in tort for failure to exercise reasonable care and skill outside the terms of any contract. On the other hand, Rome I and Rome II don't require reciprocity, so EU courts should still respect and enforce contractual choices. The EU also provides mutual recognition for jurisdiction clauses. This is potentially more serious because the Brussels regulation requires reciprocity. So the English courts will almost certainly give effect to your jurisdiction clause, but other EU courts may not, or they may not stay cases in favour of England. If you have no jurisdiction clause, you'll have to fall back on the common law rules of forum non conveniens, so you'll need permission to serve out of the jurisdiction. Now, the English courts are highly experienced and efficient at this because they apply these rules for non-EU commerce, but it involves extra cost. You have to reach a threshold of showing a good arguable case. You have a duty of full and frank disclosure when you apply, which includes putting forward your opponents a case, and so it's to be avoided if at all possible. Now, EU law also provides two simplified processes at present. One is for service of legal process. At present, you can simply serve throughout the EU without permission, and if that falls away, you may even find yourself having to go back to serving legal process through diplomatic channels in some cases. So again, it's to be avoided. And then there's recognition and enforcement of court judgments, and this is really increasingly seen as the big one because it hugely underpins the certainty of contractual effect. At the moment, you can take your judgment from one country in the EU, register it elsewhere, and enforce it as if it's a judgment of that local court. Now, the UK has some pre-EU reciprocal enforcement treaties with a number of the main EU countries, but enforcement is an area of exclusive EU competence, so there are question marks about whether those will work post-Brexit. If they don't, or where there is no treaty, you'll have to enforce in accordance with local law requirements, which almost certainly means starting fresh proceedings on the English judgment, a time-consuming process and a costly one. So how can you protect your business? Well, for much of this, you can seek contractual protection. I say seek because obviously these things depend on your counterparty's own negotiating position. And remember, it's not just new contracts. You need to look at your existing contracts, and I'd do that now because it may take you time to be able to renegotiate. If you're providing professional services, make sure you sign a contract in the first place so that you can argue that the relationship is governed by a contractual choice of law. In your contracts, specify a governing law if you don't at the moment. Insist on the appointment of an agent for service within the jurisdiction. Add a jurisdiction clause if you normally don't use one. Even a non-exclusive clause is better than leaving it to the common law. Add an exclusive jurisdiction clause if you want to ensure a particular venue. The UK courts will almost certainly uphold it, and the EU courts are more likely to uphold it. It's much harder to protect the position on enforcement. The only surefire way to do that is much more radical. That's to consider arbitration. With arbitration, you get the benefit of the New York Convention on the recognition and enforcement of arbitral awards. It provides a simplified enforcement process, similar to enforcement under the Brussels regulation, and all EU members are signed up to the Convention. But arbitration involves considering some other very important factors, such as the inability to join third parties. It can be much more expensive, and you usually have no right of appeal. It also won't work for consumer contracts. So for very significant cross-border contracts, the radical may be justified to ensure certainty of the enforcement process, but I'd really recommend you get specialist legal advice first. And finally, consumer complaints. In consumer contracts, if you're specifying an external organisation to which complaints are initially to be made, make sure you specify one in the UK, as EU competencies may fall away. And now I'm going to hand back to Sian to talk about data protection.
Thank you, Tim. So for those already doing business in the UK, you'll know that data protection is a hot topic at the moment, with increased focus from the regulator and from the public around privacy and what is happening with their personal data. For those of you that are international businesses, the demise, especially those who are attending from the US, the demise of Safe Harbour, the FTC-approved scheme which legitimised data transfers between the EU and the USA, the move to model clauses and the subsequent introduction of the Privacy Shield has meant international businesses transferring data outside of the European Union, in particular to the USA, have had an uncertain time over the last 2 or 3 years. In addition, the General Data Protection Regulation, or the GDPR for short, coming into force across Europe next May, means that all businesses operating in or targeting the EU need to step up their game in connection with data protection. So this is already a moving landscape for data protection and privacy regulation. The triggering of Brexit has led to businesses questioning what will happen next and how will this affect data protection. Should businesses still plan for GDPR? Will the EU need to have its own data transfer regime with the UK? And should data processing still take place in the UK? The Information Commissioner's Office, or the ICO, have been very clear in the period since the Brexit vote, and has stated that the UK will continue to need clear and effective data protection laws whether or not the country remains part of the European Union. So there's clear guidance and an expectation that privacy regulation remains as important as ever, and international businesses should continue to regard compliance as important to getting business done in the UK. We've had confirmation since the Brexit vote that the ICO from the ICO that the UK will continue with the implementation of the GDPR, and this will affect all businesses in the UK and all those businesses doing business and processing and collecting personal data of UK citizens. It's unlikely that the UK will have exited the EU before the implementation of the GDPR, which is due to happen next May. So upon implementation, the regulations work in full. But the question then arises, what happens after our exit from the EU? And at the moment, there is some uncertainty about how some of the provisions within the GDPR, in particular those provisions which require the European regulators to all work together, and for instance, whether the UK can be a lead supervisory authority, will continue to work. How will that work with the rest of the European Union? We expect the ICO to be petitioning the government to ensure a favourable recognition regime in which the UK and the ICO are given the same protections in respect of privacy matters, and hopefully they will allow the other European regulators will allow the ICO to be part of their network. But again, it's an uncertain picture at the moment. So, what should businesses be doing now? It is clear that all businesses operating in the UK and across Europe need, if they haven't already started to begin planning for the implementation of the GDPR. This is not an overnight exercise, and businesses need to be actively working through this now. In addition, businesses with complex European group structures who may have been relying on the UK ICO as being the lead supervisory authority may need to consider an alternative lead authority and the implications that might arise from this. The area of privacy is fast moving and staying abreast of the latest updates will be important for most businesses. Taylor Wessing have produced the Global Data Hub, which provides up-to-date news on UK and international privacy matters for all businesses, and it's regularly updated. So that's probably one of the best places to find updates and information on this topic. I'm now going to hand over to Mark, who's going to talk about IP.
Thanks, Sian. Intellectual property is often dealt with internationally, partly because that's easier for rights owners, but partly because intellectual property rights can form significant barriers to trade between countries. And as a result of that, intellectual property and harmonising intellectual property rules across the EU has been central to the EU project ever since the single market was first initiated 25 years ago. And we see across all different forms of IP rights that there's been some or a great deal of harmonisation ever since, to the extent that most IP lawyers are really not UK or French IP lawyers, they're EU IP lawyers. This has ranged from some rights being pretty much fully harmonised to some being somewhat harmonised. Copyright, for example, is half harmonised, trademarks, designs pretty much fully harmonised, some unregistered rights, no harmonisation at all. But there's an increasing move towards harmonisation, and it also applies to things like court procedures and remedies, for which there's a specific directive, and now you see cited in pretty much all case law across the EU. Life goes on regardless of Brexit, and there are initiatives underway as part of the EU digital single market, which will increase the harmonisation of copyright laws for trade in digital goods. There's the Unified Patents Court, which may for the first time introduce some sort of pan-EU approach to patents, and the Trade Secrets Directive is trying to put that on the same footing across the EU. What's going to happen to all of these changes, and in fact the overall project to continue to harmonise? I think this has two effects, one on what may happen in the UK, but also what may happen in the rest of the EU, where the UK has always been very close to and engaged in the process of changes to IP law. So, for example, procedural laws were very much based on the UK approach. So we may see a different approach as time goes on to how IP is dealt with more generally. For rights owners, the one area they'll be looking at very closely, though, is what's happening to EU-wide rights. It's been very convenient in various areas to get a single right which applies across the EU, and you don't need to worry about country-by-country approaches. But what's going to happen to some of those EU trademarks, registered community design, and things like that? So, moving to where we are now as far as we can see the landscape based upon what various political pronouncements have said. The UK's white paper, which accompanied the Article 50 declaration last week, suggested one important point which will apply to IP, which is that Court of Justice case law will continue to remain the leading case law unless it's overturned either by UK legislation or by the UK Supreme Court. Currently, the CJU is superior to the UK Supreme Court. That will mean that a lot of areas of IP which have been formed by case law more than legislation, in particular copyright, are likely to remain pretty unchanged for some time unless the UK government looks to change the law. So that may be one area where, regardless of whether we have a soft or hard Brexit, we may not see much change for a while. UK IP courts have approached remedies in a new way over the last few years on an EU basis, and so have concepts now such as proportionality as one of the most important concepts in determining what sort of injunction or remedies to grant. I would imagine those are likely to stay because that's now the modern way. It's not really a matter of whether it's EU or not, so I think some things may change. The Unified Patent Court, well, we don't quite know what may happen to that. It's been ratified by the UK government after the date of the vote last summer, and so there clearly seems to be some intention by the UK to stay involved, not least as one of the most important parts that it's supposed to be based in the UK. However, there may be difficulties with that because parts of the UPC procedure is subject to the CJEU jurisdiction, which is anathema to hard Brexiteers. It's unclear what will happen to registered rights. Will the EU trademark become split into the 27 right and a 1 right? How is that going to work? There's 10 million of those marks. Is it simply going to be an automatic vesting, or is there some procedure? If so, how will that possibly work with 10 million pieces of paper? And also, how are you going to represent, or how can trademark agents represent clients if they are simply based in one part of the EU or one part of the UK? Are they going to get reciprocal rights? No one knows yet. So what should you be doing now? There's a few things. Because there may be some profound changes to some forms of pan-EU right, you should be thinking about, will your IP protect you in the UK post-Brexit? So a number of clients, for example, are suddenly applying for a lot more UK-only registered rights, simply so they avoid problems later, or because they haven't used the marks much in the UK and they're worried that they may have an invalid mark if they don't apply soon. Reviewing licences, the impact of EU territory definitions. I mean, this mirrors some of what Sian was saying. Look for pan-EU obligations and how they may affect you or last, and whether you can enforce them after we finally leave the EU, and future-proof new licences for the new situation. If you're under or have applied for a pan-EU injunction, what's going to happen to that? You need to think about, will it matter if suddenly it doesn't apply to the UK, and is there some other procedure you can take to cover that? And finally, stepping back slightly, this could be the moment to make big changes which you always wanted, or at least to lobby for them. There's going to be a bonfire, so we're promised, to regulations by the government, and that's an opportunity to do things differently. And so, for example, some people are talking about copyright law being formed on a completely new basis, and whether or not parallel imports from outside the EU should be allowed in the UK without any problem. There's opportunities, as Paul was saying at the beginning, and it's a very good opportunity to be stating them. At that point, I'm going to pass back rather to Vikki, who's going to talk more about employment.
Thank you. I think it's fairly fair to say that employment law in the UK is considered to be very pro-employer already compared to employment laws across other European countries. But a lot of the employment laws currently are governed by Europe, and we have a significant body of case law which covers areas such as discrimination, TP, transfer of undertakings, collective consultation, paid holiday working time, and agency worker issues, all of which are governed to a greater or lesser extent by Europe. And this could be an opportunity for UK-based employment law to become more flexible and for some of those constraints to be removed. The white paper that's been mentioned already has made it clear that there is a government commitment to protect workers' rights and ensure that workers' rights do keep pace with changing labour market, but that all employment rights that have been derived from EU law will be converted into domestic law in order to provide employees certainty and continuity. So it's going to be very interesting to see which of these areas may change. It might be, for example, that in relation to discrimination law, we see a cap on compensation, which is currently unlimited. There's a hope there may be more flexibility, particularly around TUPE. Some people think that TUPE might be abolished altogether, but I think that's maybe wishful thinking. There might, however, be some removal of service provision changes, or a sort of more limited approach to when employees would change in relation to service provision. That might be very favourable to people working in the insolvency space, for example, which might make it a little bit easier to sell companies as trading entities. Will there be changes to the working time arrangements we have in the UK? There have been lots of recent case law in relation to the extent of holiday and paid holiday and what constitutes pay. And a lot of that comes from Europe. So might it be we have a little bit more flexibility there? Might there be changes to breaks and how those are paid? And the agency worker regulations, which are still relatively new in the UK, could that be considered to be unnecessary regulation? Might there be some more flexibility in different forms of working in the UK? If this does happen, might it be the case that trade unions grow to fill the gap and that we have more arrangements with trade unions, which we don't tend to see in the UK in the way that we would in other European countries? So there's a lot to be thinking about. What can you do now, though? Like I mentioned earlier in the webinar, it's important to consider your resourcing at this point. You need to be looking at your current workforce and your current and future training needs. Could you, for example, make use of the apprenticeship levy, which will be rolled out as of tomorrow? Might you be able to use that levy to train up people in your workforce to start to fill some of the gaps that might appear in the future when it's harder to recruit people from Europe, for example? Do you need to look at your recruitment practices now so that in a couple of years' time you are reaching out to different areas of the workforce within the UK? Sian has talked a lot about commercial contracts already and looking at splitting of costs and allocation of costs in the future, and that's something that's going to be very important from an employment perspective, particularly if there are additional visa costs that you need to be factoring into projects, for example. Think about those now. Do you need to be looking at your employment contracts? All employment contracts in the UK should contain clauses about the right to work of employees, and those are requiring people to have the right to work in the UK. Now, as EU nationals, we know that EU nationals have the right to work in the UK already under the right to free movement, but how will your contract cope with that if those people need to have visas in the future? Might you need some more flexibility in your contracts? Might you need to think about your incentive plans, and if employment needs to terminate because people don't have the right to work, how is that going to look in relation to rights on exit in your incentive plans? Do you need to be thinking about that and changing rules now? Do you need to be thinking about how to work with senior staff members who might be nervous about transferring to the UK and want some certainty about their ability to remain here, and how will you document that, for example? So those are things that you could be looking at now. I'd now like to pass to James Stewart, who's going to look at some tax implications of Brexit.
Thanks, Vikki, and good afternoon, everyone, and welcome to the tax segment of this webinar. So unfortunately, we can't cover all the potential tax issues of Brexit in the time we have this afternoon. So what we've actually chosen to do is just focus on one particular topic, which is potential implications for corporate structures that have UK companies in them and also companies in other EU member states. It's fair to say that in recent times the UK has become a competitive holding tax regime, and because of that it is often used as almost a gateway into Europe for inward investment, and you very often come across structures where you have UK holding companies with then a number of European subsidiaries. Some of the reasons why the UK has become popular as a holding company regime: UK companies don't generally pay tax on dividends received from their subsidiaries, so you can have a holding company in place which isn't being taxed on those dividends coming up from its EU subsidiaries. Likewise, the UK itself doesn't actually have to levy withholding taxes on dividends paid to its shareholders, and the UK has a very generous tax exemption for sales of trading subsidiaries, and it also has an extensive network of what we call tax treaties. And we'll cover tax treaties a bit later in the talk. Now, in any international structure, you will often have a number of cross-border payment flows. You'll have dividends being paid from subsidiary companies to their parents. You'll have interest on your intragroup financing, and you'll also have royalties if you have, for example, IP, which is being licensed around the group. And on any group structure, you'll want to consider what are the tax implications of these cross-border money flows. And membership of the EU does potentially impact them, which is why we're focusing on this point. Now, the current situation is happily there are two EU directives which do assist in mitigating these withholding taxes. Now, when we talk about withholding taxes, really that's just a collection mechanism. It's not a special tax as such. It's simply saying if you have, let's say, someone in the UK who pays interest to someone in another EU jurisdiction, then generally that UK person is required to withhold UK tax from that payment and pay it over to HM Revenue and Customs, the UK tax authority. Likewise, the person in that other member state might have to withhold their own jurisdiction's taxes if they paid interest to the UK. So that's all a withholding tax really is. And we have these two directives. The first is called the Parent Subsidiary Directive, and what that does is that eliminates withholding taxes on dividends paid by essentially EU subsidiaries to their EU parents. Obviously very important if you have a UK parent company that you have that directive there to eliminate those taxes. And also the Interest and Royalty Directive. As the name suggests, what that's doing is mitigating withholding taxes on interest and royalty payments. Now, Brexit will likely impact the application of these directives to the UK. For example, if we go back to our UK holding company, let's say it has a subsidiary in another EU member state, which, under the rules of that other EU member state, requires a withholding tax on dividends, it may be the current position is the parent subsidiary directive then eliminates that withholding tax, so that the dividend can then get paid up to the UK parent, and the UK parent has no UK tax to pay on it. Once the UK ceases to be a member state, we're expecting that it will no longer be able to rely on those directives. And so the potential impact is that we're introducing withholding taxes and tax leakage into structures where that currently doesn't exist because of the existence of these directives. One thing I would mention is double tax treaties. We briefly touched on those before. Double tax treaties are essentially bilaterally negotiated treaties between jurisdictions. The UK has an extensive network of tax treaties. It has a tax treaty with every other member of the EU, and those essentially are not, those are not EU rules, and so those shouldn't be affected by Brexit. And so it may be that even though we are losing the parent subsidiary directive, the interest and royalty directive, it may be that the tax treaty will step into its place and produce the same effect by either eliminating the tax or mitigating it. What I would add is that treaties, you can't necessarily rely on that. It may be that the treaty reduces a withholding tax, but doesn't completely eliminate it in the same way that, for example, the parent subsidiary directive currently does. So that brings us back to our question of what can you do now? Why are we talking about this now? And what can you be thinking about at this stage? Well, really, the main question you can ask is if you do have a corporate structure which has UK companies in it, it has other EU companies in it, and you have movements of money between those companies, dividends, interest, royalties, at this stage you can review that structure and identify, are you relying on an EU directive to mitigate a withholding tax? Are you relying on the parent subsidiary directive so that your EU member state company can pay a dividend to its UK parent? If so, and assuming the worst case hard Brexit scenario, let's say nothing else is put in place, the next question, if you've identified that potential withholding tax, can it then be eliminated under the terms of the double tax treaty? So to do that, you would then need to look at the tax treaty between the relevant jurisdictions. They're not all the same, some of them apply differently, and do an analysis then of, well, I may not be able to rely on the directives, can I fall back on the tax treaty? And if you can fall back on the tax treaty, consider what are the formalities. Do I need to make a claim for treaty relief? Is there anything I need to do to mitigate that tax? And in your worst case scenario, we've lost the directives, there's no tax treaty that will fill the gap, so you've now got a withholding tax in your structure that you didn't previously have. Then your final question is, well, can I reorganise my group to eliminate that? Do I need to put in place a new holding structure, for example, using an EU member state other than the UK? So that's it for me on tax. I hope that's been helpful. I'm going to hand over to Jonathan Rogers, who's talking about financial services.
Thank you, James. The financial services industry in the EU is governed by a series of single market directives. What this means is that under EU financial regulation, firms that have a licence in one jurisdiction can, as it's called, passport that licence into other member states across Europe. They can do this by providing cross-border services, or they can go a step further and actually set up an establishment, a branch in those other member states. That process happens efficiently. It's a process merely of notification communicated between regulators in the member states, and in a short time frame the firm can get on and do its business. So it's an extremely efficient process. What does it cover? A range of financial services, so banking, accepting deposits, and all the ancillary services we associate with our banking services, both retail and wholesale and commercial. Insurance, that covers both our sort of general insurance, such as, again, at retail end, it's home, car insurance, moving up through investment type insurance, life insurance, and mediation, so brokerage platforms. It covers investment services, advisory services, asset management, broker-dealers for buying and selling investments. It covers payment services and what are called e-money services, as well as funds operation and management. So a broad spectrum of different financial services are governed by their separate directives. What does this mean in terms of usage? Well, the FCA communicated in August last year some stats on the volume of passports where the UK are involved. From the EU passporting into the UK, you have over 8,000 firms making use of a passport. From the UK passporting back out into different EU member states, we've just got under 5,500. So quite large figures. There is, however, a lot of sectoral divergence. So, for example, in terms of the banking and insurance sector, there are 4 times as many banks and insurers passporting from Europe into the UK, whereas in the investment sector, there are twice as many investment firms passporting from the UK to Europe. It's not easy to read a great deal of detail into these stats, as it's hard to identify in any one case what exactly the volume of business is that's being passported. But they're certainly thought-provoking. They certainly illustrate that the passports are heavily used, that it's mutual, and that it underpins the basis of financial services and London playing a key part in that European scene. The passport and its important point are predicated on common regulations and regulatory oversight. It only works if you can passport a license into other member states if every member state has common rules and regulates to a common standard, and we'll come back to that theme later. In terms of the UK government's position in their recent February white paper, they respect the fact that you can't cherry pick, that the freedom to provide services is just one of the 4 freedoms, freedom of migration being another, and that we can't have one without the others, and therefore the government position is we're not going to petition to remain in the financial services single markets. In terms of where that leads us, we're going to be leaving those single markets. And first of all, to assess what the impact of that is, a lot of research has been done into whether or not so-called allowances for third country firms might support the UK going forward. These are allowances already baked into EU law that permit third country firms from outside of Europe, the US for example, to participate in the European financial services market. However, the assessment across the board is that while they provide some permissions, they're not a substitute for a full passport. They're somewhat narrow in scope and couldn't necessarily be relied on. Not least, they depend on a concept of equivalence, so that the European regulators have to assess the third country state as having an equivalent regulatory regime. And while there's a great deal of confidence that the UK will be viewed in that regard, we can't guarantee it just yet. And even then, those third country rights aren't as substantive. There's talk of the WTO rules stepping in to fill the breach where European rules recede. That won't help us in the financial services sector. They don't substantively address financial services at all, so they're not an option. Firms could look at establishing and obtaining a new license in their target jurisdiction. So UK firms using a passport could look at getting a license in another member state across Europe and using that as its European license. Similarly, European firms could look at getting a separate license in the UK. The challenge here is that it can take up to 12 into 18 months for more complicated licenses like a banking license. And also they do require duplication of capital, financial capital and human resource. You need to prove worthiness to get a license, and that means you need to have the right people and the right resources to run the business properly. So there's duplication there. The key issue that our clients are facing is really one of time. It's entirely possible that the negotiation process might result in a favourable outcome that will allow ongoing cross-border services under some mechanic or other, but we don't know that yet. And given it takes time to get alternative licenses and to move businesses, firms are really having to assume a hard Brexit, to assume no favourable solution is reached, and then plan accordingly. Things we might be looking for, however, from the negotiation process include the prospect of transitional arrangements. Even if we get to the expiry of our 2 years, might we at least have negotiated an ongoing period of mutual accord given existing passporting firms to allow them to settle in and make the changes they need to. Will the UK offer what's called grandfathering, whereby a licensed firm from Europe might automatically be entitled to translate that license into a direct UK license, so allowing them to continue business? Optimal solution is we will be able to negotiate a bespoke agreement that will fall short of full single market access, but still will allow us mutual access to the European market. It's difficult to predict what this might look like, and of course there could be, for example, financial penalties, tariffs that go attendant in that arrangement. Another area where we're beginning to see developments is the attitude of other EU member states. Will they compete for licence applications? For example, offer the equivalent of grandfathering in their own member states, whereby they allow UK firms to automatically graduate to a direct licence in that jurisdiction. It would also be very interesting to see the European approach to firms that wish to share resources across different jurisdictions, different licences, to share central management, to share costs, and whether regulators will tolerate that. One option, at least, that's sort of discussed is whether the freedom away from the single markets will allow us to change our current rules, turn ourselves into an even more competitive financial market. It's nice to think that might be possible, but it's difficult to see. In large part, any hope of an ongoing relationship with Europe on a mutual basis will be dependent on largely equivalent rules. So it's difficult to see that we could diverge very far from the current position. In terms of what firms should do now, if your business is an EU-based financial services businesses, you've got to look at what passports, if any, you currently use, and assess how deeply you use those passports. And then assess your options. Check whether the so-called third country rights I've mentioned might happen to be sufficient for your particular business to continue to do what it does now. Assess whether getting an additional regulatory licence in an overseas jurisdiction outside the UK in Central Europe might be an option. Would that be proportionate in terms of the time and expense and capital costs required to achieve that? It's possible that firms could look at entering into partnerships or agency arrangements with other entities in overseas jurisdictions that have the right licence and partner up with them. Firms should also count back from the sort of 2-year negotiation period as we get to Brexit and determine their action plan accordingly. How soon do they need to start acting on any of these points to make sure they're ready in time for Brexit? Firms also need to keep up to date with developments. The government are certainly aiming to negotiate the freest possible trade deal that they can in terms of financial services, so that there is hope that the situation will get a lot better, and firms need to keep an eye on that. If your firm is what I call B2B, so if you engage with other businesses which are in the financial services market, so for example, an insurer dealing with insurance brokers, look at how they might be impacted. Do you have key relationships, and understand how they could be impacted and how well their businesses are going to be protected. Also, what's sure to change is our regulatory landscape in the UK. I've mentioned that we might seek, and probably would seek, to keep our rules largely equivalent, but nonetheless there'll be a process of change which will trigger the need to change contracts and terms and internal processes as well. If you are not yourself a financial services business, but the consumption of a financial services business is critical to your own business, I think that the key thing is to identify who your key providers are, assess whether they use a passport themselves, and that's readily available to see on public registers, and just track what their solutions are as we come nearer to the Brexit sort of handover date, and make sure they've got a solution so they can continue to provide their services to you on a smooth basis. Now I've got to hand over to Paul just to help us close up.
So, as I hope you've appreciated from all of the various speakers, there are great opportunities in terms of Brexit and your relationship with the UK, but equally that there are an awful lot of things that you need to do to prepare for Brexit. We as a firm have created a very detailed checklist that we are working with which we're working when dealing with clients who are instructing us on their Brexit strategy, and making sure that every firm that does business with the UK has a Brexit strategy in place now is absolutely key. Needless to say, we'd be very happy to work with any company that would like some assistance in this area, whether you're looking to increase your investment in the UK in the short term, potentially taking advantage of the current currency changes. The pound has fallen approximately 15% against the US dollar since the referendum, and we're seeing clients taking advantage of relatively cheap acquisition opportunities. Or if you're looking to make sure that your business is prepared for Brexit and doesn't suffer any unexpected surprises, or alternatively, if the UK is your only place in the current EU in which you're doing business and you want to think about dipping a toe into another EU market post-Brexit, then we can certainly advise you on the best options for that. Overall, the UK does remain the most business-friendly, competitive place to do business, but certainly until we know precisely the shape of the deal that the UK does with the European Union, it may be prudent for some businesses to ensure that they do have some presence in another EU country other than the UK if they don't currently. Although we've had a few questions have come through, partly because we're running out of time and partly because it might be easier to go into more detail one-on-one, we'd strongly encourage you to contact the member of the Brexit team that you're in relation to whichever area you have questions. And you can see everybody who has registered for this webinar will receive a copy of the slides, and you can see on the last page there we have everybody's contact details. So we hope you found this helpful, and we'd be very happy to work with you in relation to any questions you have regarding Brexit and how it might impact your business. So thank you very much for joining us today.